Morning. Welcome to our last day of March oral arguments. First case of the morning is Masserant versus State Employees Retirement System. This is a 15-minute mini oral argument on the application. You have time for rebuttal. We ask that you reserve that and keep track of your own time. And you may begin when you're ready.
Thank you. Please support. My name is Russell A. Smith. I represent Adam Masserant in this matter. This case is a request for leave to appeal. It has procedurally gone through all the normal steps: administrative hearing, circuit court, court of appeals, and we find ourselves here. This is a direct challenge to a statute, 38.67, small a, parens 5, parens small b. In order to qualify for a non-duty disability retirement, the claimant has to satisfy 3 prongs of the statute, and there's only one that's at issue, and that is the parens b, a medical advisor conducts a medical examination of the member, certifies in writing that the member is mentally or physically totally incapacitated for further performance of duty, that incapacity is likely to be permanent, and the member should be retired. Now, that requires a certification from a medical advisor. Now, the medical advisor is not defined by statute. A fair reading of it by a layperson might convince them that the medical advisor could be their treating physician. However, the medical advisor is picked by the very defendant in this case, the State Employees Retirement System. They pick a medical advisor. They pay a medical advisor. Any claimant has to get a certificate from this medical advisor in order to receive non-duty medical retirement. We believe that this is a violation of procedural due process in that it deprives the claimant of property without the due process of law.
Counsel, could you tell us, good morning, could you tell us what the property interest is?
Yes, property.
That seems to be the key essence to this. And so, yeah, if you could really emphasize the property interest and give a full explanation of that.
I appreciate that, Justice Bernstein, and that is a key issue. The Attorney General has indicated that a unilateral expectation of a benefit is not a property interest. However, this is not unilateral. This is a bargain for consideration, and it is extremely valuable. The medical retirement replaces an income stream of the claimant, and it's not unilateral, it's bilateral. You work for us, you are medically unable to continue, you receive this benefit, okay? And what prevents that, in this case, is the requirement of the certificate from the medical advisor. So that prong of that statute deprives anyone from receiving a fair hearing on whether they should receive this benefit or not. So that is a property interest. Mettler-Walloon versus Melrose Township, protected property interest is present where an individual has a reasonable expectation of entitlement. Not an absolute guarantee, but a reasonable expectation of retirement. And I think in this case, Mr. Masserant certainly did have a reasonable expectation that he would receive this benefit. And it also requires that any hearings take place in front of an impartial decision maker in a meaningful manner. The medical advisor has replaced all the judicial heads that look at this case, because if that certificate does not exist, they have no discretion, despite whatever evidence a claimant might bring. Years worth of medical records, x-rays showing degeneration of discs in the spine and neck, isn't true in this case. They can't consider any of that. Even though they will listen politely, they're no longer the finders of fact.
Well, Mr. Smith, I understand the position that, your position that the way the statute is written, that is the case. But I think here, what do we do with the fact that it appears to me that the ALJ reviewed the medical advisor's evaluation and found that it was supported by competent material and substantial evidence, whether or not the statute sort of permits that or not. But here, it appears that the ALJ did review that evidence. What would, in this case, what more would you propose that needs to be done, or what's the remaining deficiency in a due process context in this case?
Well, the due process context in this case, and thank you for your question, is that we introduced evidence of all of the medical records of Mr. Masserant. However, they were not considered in making the determination. The determination was that there was no certificate. Every determination all the way up, and the Attorney General indicates that my client was satisfied in due process because he had hearings. But the hearings only consisted of, was that certificate signed? Nothing else. All the materials we brought in weren't considered. The trial judge in Polania, he looked at that statute, could not believe that the medical advisor would be the first, last, and final determiner of facts in this type of case. So he looked at the case in chief. He considered all of the evidence and found that the claimant had won by clear and convincing evidence. So what we're looking for, we believe that it's unconstitutional. We're looking for something which would allow the supposed finder of fact in all these hearings the opportunity to consider the medical evidence of a claimant from their treating physicians who possibly have treated them for years and years, rather than be bound absolutely by lack of a certificate for a medical advisor who possibly only met the claimant for 20 minutes and reviewed the records. We don't believe that that is fair. As this court is aware, in a personal injury case, if they get an IME, the insurance company, then the insurance company might cut off benefits. When you get to trial, the IME is one piece of evidence, and the plaintiff can introduce evidence from his medical experts with the finder of fact determining who should prevail. Here we have a conclusory certificate from a person that you can't contest, you can't fight, you can introduce evidence, but the presiding administrative judge or judge can't consider that.
So what would you propose, what's your proposed remedy then? Do we strike that portion of the statute? Do we judicially sort of engraft a requirement that, yes, fine, you can keep that statute, but the claimant has to be able to present competing evidence, and the ALJ needs to be able to consider that against the opinion of the medical advisor?
That would be fine. In fact, that very procedure existed previously in a duty retirement under the same system, where it said that the claimant must get or provide a medical certificate from the medical advisor, or the claimant could be granted benefits if the presiding judge or administrative hearings officer disagreed with the medical advisor. That gave discretion to who supposedly is the finder of fact. It wasn't conclusive.
That language that you just cite, that was in statute, or the court imposed that?
It was contained in a statute, and it was, again, the same retirement system, but for duty injuries. Here's a non-duty injury.
Well, and in fact, in 38.67A sub 1, that is the existing structure for a qualified participant because of duty. But we're looking at sub 5, which has very different statutory language.
Right.
So what are we supposed to do with that?
Well, that's why we're here. I think if that provision were to be struck as unconstitutional, then the finder of fact could consider all evidence. And that would be fine. We're looking for a level playing field. My client did not want to claim medical retirement. He was forced to. And the asked for an accommodation. State said, we can't accommodate you because your physical condition is such that we do not have a job which you could perform. They denied him an accommodation. And he was forced to claim medical retirement, and he has a degenerative arthritic condition which only gets worse, as I'm sure all of you are aware. So he and all other similarly affected people are in a catch-22, and that it needs to be fixed. And again, all we're asking is for a fair hearing. We're looking for a meaningful hearing. And again, I'm not deriding any of the judges or hearings officers that we've appeared in front of. Their hands were bound. Some of them were very sympathetic to his claim, but in the end analysis, they were forced to follow this restriction in the law. Polania, although it did not upset this particular provision, and again, it's another statute, but it's absolutely on point with this, identical, but it was very sympathetic to the claimant, to the point that it talked about the fact that it was unfair, but they felt bound to uphold it. And again, we're just looking for meaningful hearings. Quite frankly, if we would have been on a level playing field when this was heard in front of the last hearings examiner, we would have won in a walkover. The evidence was totally conclusive. We had x-rays of the spine which showed many, many defects and many problems. We had treating doctors that had been with him for years and watched his condition disintegrate over the years. Again, the last hearing officer, we presented all of this evidence. He listened very politely, but his hands were tied. It's unusual. I, along with the trial judge in Polania, were appalled to find out that this was the system which was set up. And again, since the medical advisor is appointed, paid for by opposing party, you get into a situation where there may be not intentional bias, but bias in favor of the system, and also a pecuniary interest in that the medical advisor could reap income from these examinations. So overall, it's a problem. It needs to be fixed. I know that this court doesn't write the statutes. I understand that, but this one is particularly heinous in my experience. I have never seen another more oppressive statute which bars people from exploring areas in their claim that they should be able to explore. I thank you for your time. With the court's permission, I'll reserve my final 2 minutes for rebuttal.
Thank you.
Good morning. Assistant Attorney General Emily Zilgett, appearing on behalf of Respondent State Employees Retirement System. With me at council table is Assistant Attorney General Jessica McGivney. The first inquiry in the due process analysis asks whether there is a protected property interest. This case can be resolved on that first inquiry because the State Employees Retirement Act does not create a protected property interest in a non-duty disability retirement benefit. Property interests do not come from the Constitution itself. They come from independent sources such as state law. And the party seeking the due process protection must have a legitimate claim of entitlement to the benefit. But not all state statutes that confer a benefit create protected property interests. That gets to the legitimate claim of entitlement, and that is created when there are substantive limitations on discretion or where there's a mandated outcome in the statute. Benefits that are discretionary, that can be granted at the discretion of the government official, do not create protected property interests for purposes of due process. The non-duty disability retirement benefit that's at issue in this case is a discretionary benefit, which we know from the language of the statute. The introductory clause of subsection 5 provides that the qualified participant may be retired provided certain conditions are met. And the word may denotes that discretionary authority. I'm happy to waive any free fire time I have. I think I have a little bit, so I'm happy to waive the remaining time. The word shall is a command, and we don't see that in subsection 5. So in subsection 5, the Retirement Act does not mandate any particular outcome. We can also compare subsection 5 to subsection 1 and other provisions of similar retirement statutes. So subsection 5, as we know, is non-duty disability. Subsection 1 is duty disability. In the introductory clause of subsection 1, it uses that mandatory language shall, the qualified participant shall be retired, provided certain conditions are met. We can also look at the Public School Employees Retirement Act, which of course is not at issue in this case, but it's a similar non-duty provision, but it also uses the word shall. The language, paraphrasing here a bit, but if the retirement board finds the member to become totally and permanently disabled, that member shall receive a disability allowance. So we can see through these comparisons that the legislature knows how to use the word may, knows how to use the word shall, and in subsection 5, it made that decision to use the word may to make this a discretionary benefit. Where no outcome is mandated in the statute, it does not create a protected property interest. And for that reason, we submit that this case can be resolved on that issue.
Counsel, I'm wondering, in this instance, everything hinged on the medical advisor and the certification or lack thereof. Is there ever a way to challenge the opinion here? Is just all comes down to the doctor or the advisor?
Yeah, thank you, Justice. I do think there is a way to challenge that. I think that gets into the second step of the due process analysis, which I'm happy to get into, but that is through the contested case procedure of the Administrative Procedures Act. So through that procedure, petitioners can submit additional medical records, they can testify, they can call witnesses, they can submit briefing, they can file exceptions to proposals for decision. So there's several steps along the way where they can either submit additional medical records for consideration or present at least their arguments that here is why the medical advisor got it wrong. And the ALJ does have that discretion if the ALJ believes that the independent medical advisor's conclusion is not supported by the record. It does have that discretion then in the contested case procedures to remand it back to the independent medical advisor for further consideration.
Can they appoint an alternative advisor?
It typically does go back to the same one, although I have seen before where it does go to a different one, so I would say that that's, maybe if it's requested and if there's a reason or if it's ordered.
So it's possible?
It's possible. I don't know that that would necessarily be standard, but it is possible and it does happen.
And that authority to do that is under the APA?
Under the APA, yes, that's correct. So that is the procedure that then provides the challenge. I think, I mentioned some of these, the ability to call witnesses to testify, but if I might just walk through the process kind of beginning to end, because I think you can see when that happens that there are multiple steps where decisions can be changed or minds can be changed. So there's, of course, the application stage, and that is where the medical evidence is collected. If an independent medical advisor concludes that the applicant's not totally and permanently disabled, that applicant can request a hearing under the contested case procedures of the Administrative Procedures Act. At that stage, the applicant can provide additional medical records. Time has lapsed. If something wasn't considered, there's the opportunity to provide additional medical records. And just for a point of clarity, the independent medical advisor's determination is based on the medical records of the applicant. So I think it's a little bit of a misnomer to say that competing evidence isn't considered when this is based on the evidence that the applicant submits. It's their own medical records. So a hearing is requested by the petitioner, chance to submit additional documentation.
Can I interrupt real quick? So at this point, it's just additional information. It can't be that the petitioner is saying what was considered in my initial application, that the advisor got it wrong.
Justice, no, I do think that that can be said too. I think that's really ultimately just a difference in conclusion. So when you're, and I think that the most efficient way or most comprehensive way to try to change a mind is to provide additional evidence, to provide medical documentation. But you could also say, here's records that I did submit, they were not considered, or I do not believe they were considered efficiently or sufficiently. So it doesn't necessarily have to be additional records. I think it could be, here's something that wasn't considered.
Are you aware, or can you point us in the direction of any opinion from the Supreme Court of the United States or this court holding that basic eligibility requirements for a public benefit is unconstitutional because it's in violation of due process?
Let me make sure that I'm understanding. So the Supreme Court or this court that public benefits are unconstitutional in violation?
An eligibility requirement. In other words, you get benefits for X, and the claim is X is a violation of due process.
I am not aware, as I stand here today, of any that have actually held this eligibility requirement does violate due process. I think usually how the Supreme Court analyzes this is then under the framework of the Matthews test. So it maybe isn't exactly looking at an exact eligibility requirement to strike down as unconstitutional, but applying that balancing test. Does that answer the question? I didn't have a case.
Eldridge v. Matthews is what you're referring to?
I'm sorry, pardon me?
You said the Matthews test. Eldridge v. Matthews is what you're referring to?
Yes.
Notice of a claim and an opportunity to be heard.
In a meaningful opportunity to be heard. But it also established, the Matthews established that three-factor framework. So under Matthews, again, this is assuming there's a protected property interest, but under Matthews, then the court would consider the first factor is the nature of the private interest. The second factor is the risk of an erroneous deprivation. And the third is the probable value of additional or different procedures. So often the procedure part of this is then analyzed under that three-factor framework.
And you're not aware of any case where under that framework there's been a conclusion that or eligibility requirement is unconstitutional in violation of due process?
I'm not aware of anything that's an eligibility requirement. In Matthews, there was a concern about pre-deprivation and post-deprivation. And in Matthews, I think one distinguishing factor is that applicant was already receiving the government benefit.
Right.
So it was a issue of termination versus application. In my research, no, I did not find that eligibility requirement X is unconstitutional.
Okay, thanks.
Just if I can circle back to the procedure. So then the administrative record is compiled, which includes all the medical records. The petitioner gets a copy of that. A notice of hearing is issued. That's another opportunity to provide any other documentation that you might wish to provide. Then a hearing is held. That's before an impartial administrative law judge. After that, parties can submit closing briefs and reply briefs. After that, there's a proposal for decision, at which point a party can file exceptions to the proposal for decision, and then it goes to the retirement board. So there are really multiple stages throughout here. And if at any point the administrative law judge or the retirement board thinks the ALJ did something incorrect, didn't consider something is wrong, it can be remanded back to the independent medical advisor for another review, another
How
look
often
at
does
it.
that happen? I mean, have you taken a look at some of these and that go through the process? And I guess ultimately I'm asking you to respond to Brother Counsel's statement that the ALJ's hands are tied with these cases.
Your Honor, I think this happens pretty frequently. It happened in this case. There's a initial report of the independent medical advisor. Additional records were submitted. There was a supplemental report. The independent medical advisor reach the same conclusion, but that does happen, and I have seen it happen where the independent medical advisor, upon additional documentation, has reached a different conclusion, and it's not uncommon.
What about with the ALJ, though?
With the ALJ,
Once it gets to the ALJ?
Oh.
Because what you just described is kind of at the beginning of the process before it gets to the ALJ, is what I heard. Maybe I don't have that right in this
no,
case. but-
I think you're correct, Your Honor. I think the ALJ also does have that authority. So the ALJ is looking at the entire record, and under the APA, the standards, competent material and substantial evidence on the entire record. So if the ALJ does not think that the independent medical advisor's report is based on that evidence, then the ALJ also, yes, has the ability to remand that back. Are you asking if the ALJ can find someone?
I'm asking how often that happens.
Oh.
How often a case gets to the ALJ where they say, you know, not just on the basis of the advisor's decision that it didn't meet the criteria, but because something else was supplemented, or because petitioner has provided an argument where they looked at it, you know, from scratch, looked at everything and said, no, this has got to go back. You need to review this again.
So, Your Honor, I don't have necessarily exact stats. I can, you know, these are cases I handle. I can speak, you know, in my experience. In my experience, I mean, I would say maybe 20-30% of the time that happens. It's pretty frequent. I think oftentimes new medical records come in. We need to take a look at them. The ALJ finds something that maybe, you know, we hadn't considered. So it is, I think, a pretty common exercise for that to happen. It's not unusual at all.
Thank you.
Just to also briefly respond to some of petitioner's arguments. So one thing he really had focused on was the pecuniary interest. I don't think there's any allegation here that the IMA had a pecuniary interest in the outcome of this case. And I think to accept the petitioner's argument here is essentially to rid the process of the IMA, because any time by his argument an IMA receives some kind of payment, that would put him in a position to have a pecuniary interest. But also just to point out that he is not alleging that the ALJ or the retirement board had any sort of impartiality at issue here. And also, just as a final point, Justice Kavanaugh, I think that you had asked some questions about the relief, or, you know, how to graft an opinion here. And I do think that's a consideration. While he's asked for the statute to be struck down as unconstitutional, the exact relief is a little unclear. I think if you strike down subsection 5, you're left in a position where there's no non-duty disability retirement. And I don't think that's an outcome that necessarily anyone wants. And ultimately, the question here is not the merits of the deprivation, but the procedure available. So if there's a better version, or we think the statute should say something different, that's not necessarily a role for this court to undertake. That would be a legislative decision. Unless there are any further questions, we would ask the court to deny the application or affirm the Court of Appeals.
Thank you.
Thank you.
Would simply indicate that all of the hearings that the AG's office spoke of are available. My client took advantage of all those hearings, and although medical records were furnished, all of the administrative law judges, circuit court judge, court of appeals judge, couldn't consider them because of the medical advisor certificate being
Well, I
missed.
think what she's saying, and I'd like to, is that they can be considered, and they were considered by the ALJ in terms of evaluating whether or not the medical advisor's opinion was supported by material, competent, substantial evidence, right? And I'm wondering, what's the meaningful distinction between what you say is lacking, which is the ability of your client to present competing evidence to establish the right to the benefits. And what is provided under the APA, which is the ALJ is reviewing that evidence to determine whether or not the medical advisor's opinion is sufficient. Like, is there a meaningful distinction between what you say is lacking and what is it, I mean, isn't it arguably just a different way of saying the same thing?
No, I don't think so, respectfully. And that is that they don't have the discretion to overrule the medical advisor's lack of certification. All
Can they find
do-
it's not sufficient?
Say it again?
Can they find that there isn't a proper certification because it's not supported by material evidence?
No. They look, is there a certificate? Is it signed by the medical advisor? That's it. That's a threshold. And that is exactly what we're trying to eliminate, is that prescription based on that section of the statute. That is exactly the essence of it. It deprives a meaningful opportunity for future hearings, and it's grossly unfair.
Thank you both. The case will be submitted.